Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, the podcast where Florida families get clear, compassionate guidance through estate planning and probate. Sophia Morales here with attorney Jamie Cuzmar, founder of the Cuzmar Law Firm. Whether you're planning ahead or navigating the legal process after losing a loved one, this show is here to make complex topics feel understandable and manageable. So let's get started. Welcome back, Jamie.
Thank you, Sophia. Always a pleasure.
So on my list today is to discuss what probate really looks like and dispelling some of those myths. So let's start with that. What is probate and why are people scared of it?
Yeah, so probate is the state's default process to pass on a deceased person's assets, to settle any debts with creditors. And so, why do people fear it? Because the default scheme is not always what they have in mind or not always what they wish to happen. So, when I say default scheme, there is an inheritance delineation that the state looks at first. If the person is married, then the spouse is usually the first in line to inherit assets from the deceased spouse. Then, if the spouse or the person is single and not married, then any descendants, any children are next in line. And then after the children, if there's no children involved and no spouse, then it would be the person's parents if they're still alive. No parents, then it goes down to brothers and sisters. So obviously, some people don't want to leave certain things. To say one thing that I see a lot is where the person had no relationship with their adult children. So if the children are already adults, keep in mind that you don't have to leave anything behind to the adult children. You can specify to leave it to your best friend if you wanted to. So that is where planning ahead will play a vital role because one, you don't necessarily want to leave it to people that you have not even had a relationship with, number one. But if you didn't do the planning ahead, then that would be the default order and you would couldn't change it. You couldn't come back from the dead and make those changes. And so people fear probate, one, because they're not knowledgeable as to how probate works. But the main fear is the costs involved and the time that it takes. So a lot of times families want to bypass that and make it things easier for the people that you leave behind. So that's why I tell people estate planning is an act of love. Planning ahead is an act of love for the people you're leaving behind because it certainly make it easier for them. For those that don't know, probate can take, on average about 8-9 months to over a year if for whatever reason there is a conflict. Think, parties fighting over a certain asset or other family members getting in the mix that you perhaps didn't foresee having some kind of claim. So one big thing for people out there that have blended families, that's a perfect candidate for estate planning. If you have stepchildren, you might not necessarily want that stepchild to have a claim on the house that, say your spouse passed away and she had, for example, a daughter before the marriage. Now, all of a sudden, if it goes through probate, that daughter or that stepchild may have a claim or half of that property might be able to distribute it to somebody didn't have in mind. So that's an important thing, especially for, so many mixed blended families out there. Like my own, I have a stepdaughter and we had to plan for that accordingly and vice versa. My wife necessarily, didn't want my firstborn son to have a claim to the house and something happened to me first. So there's ways to plan ahead and avoid those situations.
You mentioned people are intimidated by the unknownness of the process and the time that it takes and the expense. So how expensive is it and who pays for this?
Yeah, so just because somebody passes away doesn't mean that probate is automatic, right? So somebody has to petition the court to open up a case. Now, if somebody doesn't have any assets, that's a prime example of why a probate may never occur. If there's no assets to be gathered, no assets to claim, then there is no probate in most cases. Now, if a family of a deceased person doesn't file for probate, then sometimes a creditor, after a certain amount of time, may file for probate to gain some of the debts that are owed to the creditor. So that's kind of rare. Most of the time the family will open it up for them. But in cases where there is a debt to be paid, a creditor may very well, if the debt is large enough, go ahead and open it because they have to also pay their attorney's fees and court fees to get the petition going.
So the person that brings it to probate is the one who's coming out of pocket then.
Right, right. In most cases, it is a person, the petitioner has to come out of pocket. So it can be expensive if there's a lot of assets. So probate is calculated, the fees for probate is calculated based on the assets that the person is trying to retrieve from or get permission from the court to retrieve. So on average, it can vary from about 3 to 5% of their overall estate, but that can add up pretty quickly considering most homes nowadays are upwards of $400,000 or more. So if a home that this deceased person left behind, an easy calculation I tell people is just go ahead and multiply all the assets that you're trying to reach through probate times 4% or 5% just to kind of cover the additional, court filing fees and stuff like that. And you can see very quickly that it can, grow from anywhere from, $3,500 for a simple probate to over $10,000 or more. For example, I've had clients that have real estate investments and they have 15 plus homes
Right.
that, it's about $50,000 and up to get access to those 15 properties. Again, it all based on the fair market value of the asset you're trying to attain through probate.
So this begs the question, are all assets subject to probate?
That is a great question. And luckily, no, they're not. So most assets, like think financial accounts, those are all exempt as long as there is a beneficiary to pay out to. Okay. So although some assets are exempt, so think a vehicle, think of a bank account, a life insurance policy, retirement accounts, 401ks, those are typically exempt, but they could fall into probate inadvertently if the beneficiary form was never filled out or if the beneficiary list somebody that's already passed away prior.
Mm.
So if there's nobody to connect the dots to or nobody to pay out to, then the court will have jurisdiction and then it would have to go to probate for the judge to decide who it ultimately goes to. And so the more that falls into it again, the more expensive the probate will be. So I tell clients when they come see me is, hey, some of these assets are exempt as long as there's a beneficiary. So make sure you list a primary beneficiary and even a contingent beneficiary. That way you don't have to sit there and fill it out all over again. If something happens to beneficiary number one, then at least you have the backup already in place and that can avoid a lot of headaches there. One of the things I
Right.
get in probate, one of the things that I see a lot get locked out of people's out of the bank accounts. Okay, so just because you're married again doesn't mean if your spouse had an individual, not a joint, but an individual bank account, the spouse won't be able to access it anymore. Upon that person's passing, and the bank catching wind of that person's passing, it's going to get locked down. And even if you had to use some of those funds to say pay the mortgage or continue paying certain bills, you won't be able to until you go through that probate process. So save yourself a lot of time and headache by making sure you have the beneficiaries listed on those accounts.
You mentioned earlier that some kinds of probate are more expensive than others. What are the kinds of probate available?
Yeah, in Florida, we have two different types. There is a formal administration, which is the typical one. And then we have a summary administration. So the summary administration is just a condensed form. So as long as the decedent had less than $75,000, according to today's laws, if they have less than $75,000 to retrieve or in assets, then the petitioner, the survivor, can go ahead and petition for a condensed form of probate. And so it typically lasts about half the time. Instead of 9 months, you're looking at like maybe 4.5 months in most cases. And it's also a little bit less expensive. So it's not quite as expensive as a formal probate because a formal, you have to consider that there's creditors that come into play. There's also additional filings, more paperwork, and more for the actual personal representative to do, to manage. So the formal probate sometimes are necessary if you're dealing with like out-of-state banks. A lot of times the banks will not abide by a judge's order in Florida. If it's a bank that's only solely in another state, you might have to go through formal probate anyway just to get what's called a letter of administration to allow the bank to release those funds to the personal representative. But another way for a potential client to qualify for a summary probate is if the person is not only under the $75,000 threshold in total assets, but if that person has been deceased for more than 2 years, then that's another way for the person to qualify, opening up a summary probate for the decedent, for the person that passed away.
So you mentioned the personal representative. What is their role in the whole probate process? And does it cost them money? Do they get paid money? How does all this work?
So the personal representative's role is to see that the assets are delivered to the right people. Number one, that they're going to abide by that person's will, if there is a will. If there is no will, then of course through the default scheme that the state has for the decedent, like the familial relationships, who's in what priority role, married or not, descendants or not. So the role of the personal representative is to oversee all these things, its assets, make sure that creditors get paid based on whatever assets are available, if there are any available. And of course, and the other role is to make sure that they close the decedent's estate. So it is quite a task. I mean, the personal representative could elect to get paid out of whatever assets are available through their probate. If they, took on a lot of work, then it's not unusual for the personal representative to seek being reimbursed. Think funeral expenses, burial expenses. Sometimes those things have to be paid out of pocket because you don't have access to these accounts sometimes, or from the decedent's accounts might be locked up already. So you'll pay things out of your own pocket, but then you can seek to be reimbursed through the court or through probate.
So, what are some of the mistakes you see that delay or complicate a probate?
So some things that can delay or complicate a probate is not having a will. Number one, failure to create a will or failure to sign the will properly. So in the state of Florida, you have to have two witnesses for a will to be able to legally deal with property, for example. Like if
Okay.
you have named a power of attorney, for example, and there's no two witnesses that are not on that, then that power of attorney can't legally transfer title to homes and stuff like that. But also making a will, like trying to draft one on your own where it's unclear. You might not realize when you're trying to draft stuff on your own that there's conflicts or things that might not be legal. For example, in a will in Florida, you're not able to relieve people of liability. For example, you can say one popular thing that people used to put in the wills is, hey, if somebody challenges the will, then they're cut out automatically. So that's no
Oh,
longer
yeah.
possible in a will. So I see people trying to do that or have very old wills or things they try to prepare on their own. And that complicates the probate process because if that will is admitted, for example, a judge will, review that. And then all of a sudden, something that you left there intentionally might get thrown out because you didn't draft it properly or didn't know that that was not allowed. So I definitely advise people to get some professional assistance when drafting these things. It doesn't have to be my law firm, but definitely a law firm that focuses on this type of stuff. That way, make sure that your wishes are honored when the time comes.
Sounds like an important thing to take into account. This isn't a place where you want to DIY it and then you don't find out, but your family finds out later that it wasn't quite what you had planned on. So, if you have a will in Florida, is there a way for you to avoid probate or does it automatically have to go into probate?
So a will alone will require probate. So that's a common misconception. A will is something that you can prepare and leave all your wishes known. And yes, the court will most likely honor them, those wishes, but you can avoid that by either going through a trust, for example. A trust is, think of a will on steroids, which will allow you to bypass probate. The other option is a ladybird deed. A ladybird deed is something that will manage your properties and keep the homes out of probate. So the limitation of ladybird, however, is that it only manages that one piece of property. So you have to do either several ladybird deeds or just put all the houses under a trust. So I tell clients all the time, if you have more than one house, then a trust makes sense because you can put multiple assets and even houses and properties from other states into that same trust versus having to do a ladybird deed for your houses here in Florida. And then, of course, houses that are not in Florida, then a ladybird deed might not be an option because the ladybirds are limited to just 5 states in the U.S. right now.
Yeah, I was going to say, I think it's a handful.
Right.
So, as far as probate goes, is there any protection from creditors when you go through probate, or can they go after all the assets and strip the bones bare?
Yeah, so most assets in probate are not protected, but luckily, if the primary home usually is. So there's something called a homestead protections for the primary house of the decedent. So that is typically exempt from creditors' reach. They can't force a sale if that was the only home. But if the person had multiple homes and the other homes are exposed, the other homes can be reached from creditors. So the protections there, I mean, are limited for other assets, but the primary home is normally the primary one that's protected. Other stuff can be reached by creditors. For example, say you had a life insurance policy. Normally that's protected. Normally that falls outside of the probate, right? But consider now all of a sudden where the life insurance policy has nowhere to pay out to because the beneficiaries weren't correct, or the beneficiaries are no longer there or never filled out to begin with. Then all of a sudden that asset falls into probate. And then if you have a big creditor, like say a medical bill, trying to reach into the probate assets or the decedent's asset through probate, then that becomes exposed.
And would the situation be different if you had had a trust instead of a will?
Yeah, yeah, absolutely. And the trust again is very good at contingency planning. So even if you forgot to name a primary beneficiary, but as long as you listed the trust somewhere as a beneficiary, then that's going to be held by the trust and then managed by the trustee or the manager of your trust to oversee distribution of that asset.
And I know we've kind of brushed up against pour over wills. Would that kind of save your hind end from the creditors if you forgot to title it to the trust?
It could. So the pour over will, of course, is a limited, has limited use. But if you act quick enough, then you can, as long as you had a pour over will to begin with, to go ahead and move the asset into the trust. So people that have wills, a simple last will and testament, are typically not going to have a pour over will.
Right.
Usually, they will have a trust in combination with a pour over will that will provide for that additional contingency.
Is there anything that I didn't ask you that we should be covering in this segment today?
As far as probate, I would say it's a good idea to start inquiring into probate early enough, okay? Because the longer you wait, the more things start to get locked down. And then all of a sudden, you're in a stressful situation where you don't have the funds to pay off the bills that you're used to your spouse paying for you or auto paying from his account. And all of a sudden, if that person's account is locked down, here you are scrambling to try to gain access to that account again through either probate, hopefully through the beneficiary form,
Right.
which is much quicker. But all of a sudden, if you're in probate, you're going to be rushing and tempted to push the attorney to, I need this done yesterday.
Yeah.
But there is, unfortunately, the time that it takes to go through the probate filing and the request from the court, and also sometimes having to put creditors on notice, to let them know that this person passed away. There is like a 90-day period that you have to wait before those assets can be distributed to the loved ones if it goes
Mm.
through that type of formal administration. So things to definitely consider is that you're not going to get access to money, in a matter of days. It's going to be thinking a matter of months, sometimes half a year or more, before
Mm.
those locked accounts you can be able to access again.
Wow. Okay. Well, thank you for sharing all of this today. This has been very helpful.
No, you're welcome. It's a pleasure.
And thanks for listening to Will's Estates and What Comes Next. If you found today's episode helpful, be sure to subscribe, leave a review, and share it with someone you care about. For more information or to get in touch, visit kuzmarlaw.com, and we'll see you next time.
Thank you, Sophia.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.